My view on the Commerce Clause, the secret weapon of Congress, is that it has its positives and its negatives. In the Constitution, it clearly states in Article 1, Section 8, Clause 3, Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. By saying this, it is without a doubt that Congress is the governor of commerce. However, that power over commerce is very undefined. There is really no clear definition of commerce in the Constitution, so in a sense, Congress can define commerce to whatever they want it to be. Congress is given absolute power over everything related to trade, and they use this clause to also regulate the things around trade and the things that are used to trade. One big example of the abuse of the Commerce Clause would be during the Civil Rights Act of 1964. The commerce power was invoked to expand federal criminal legislation as well as for major social reforms such as the Civil Rights Act of 1964. But in United States versus Lopez and United States versus Morrison, the Supreme Court limited Congress's power under the Commerce among the States Clause for the first time since the 1930s. In Lopez, Chief Justice Rehnquist wound his way among the court's precedents to strike down a federal law that had criminalized the possession of a gun near a school. He declared that the commerce power extends to the use of channels of interstate commerce, the regulation of instrumentalities of interstate commerce, or persons or things in interstate commerce, and a local commercial activity having a substantial relation to interstate commerce. Possessing a gun is not a commercial activity, even though gun violence affects commerce. More importantly, he argued that the effects prong of the commerce power applies when the activity is a commercial activity. He insisted that the rule of substantial effects must be observed. Justice Breyer, who was dissenting, disagreed that there are limits to the commerce power. It does not grant a general federal police power. But he could not find those limits. He argued that there is a sufficient connection between guns near schools, the impact on the educational process, and the eventual connection to the nation's economy to justify the regulation. But he could not, under his formula, put forward any activity that could not thus be reached by Congress under the Commerce among the States Clause. Concurring with the majority, Justice Clarence Thomas suggested that the proper occasion the court should re-examine some of its more expansionary precedents dealing with the effects test. Subsequent to the decision, Congress amended the law requiring that the particular gun found in possession near a school must be shown to have traveled in interstate commerce. In Morrison, the court struck down a suit for damages for rape, even though the suit would have been permitted under the Violence Against Women Act. Here, Chief Justice Rehnquist explained Lopez by emphasizing that non-economic activities, as in violence against women or violence against men or violence in general, could not be aggregated to establish a substantial connection to interstate commerce. Although there are these examples of Congress using the Commerce Clause as a bit of a stretch, there are also practical reasons for Congress to regulate commerce and it being beneficial for the population. In Granholm versus Herald, in 2005 was a court case decided by the Supreme Court of the United States in a 5-4 decision that ruled that laws in New York and Michigan that permitted in-state wineries to ship wine directly to customers but prohibited out-of-state wineries from doing the same. Eleanor Heald, a wine collector, and 11 other people argued that Michigan's liquor control code violated the DCC by making it a misdemeanor for out-of-state wineries to ship wine directly to a Michigan resident while not prohibiting direct shipping by in-state wineries. The same argument was made in a separate case against the government of the state of New York by Juanita Swedenborg and a few other out-of-state wineries. In these two cases, the state governments of Michigan and New York had argued that Section 2 of the 21st Amendment granted them carte blanche to regulate liquor. One of their justifications for the laws was that by regulating out-of-state wineries in this way, they might be able to hinder the shipment of alcohol to underage minors. This would serve a valid state purpose. In the 5-4 decision, the Supreme Court decided the state laws were unconstitutional. The context of the 21st Amendment was to return to the status quo that existed before Prohibition, making it clear that the states had the power to regulate alcohol however they wished, including banning alcoholic beverages entirely within the state if desired. Before Prohibition, the states did not have the power to violate the Dormant Commerce Clause, and the 21st Amendment was not intended to grant them this power. Although these examples show only a small part of the good and the bad of what the Commerce Clause can do, there are other examples. The Commerce Clause is invoked much more often and in so many different ways than one would expect. So again, I think there are some positives to the Commerce Clause. However, I think that there are also negatives and that there needs to be more clarification on what commerce actually is and how far Congress can go to use that clause.